Let's talk about some of the observations of regulators when it comes to startups. It's early in India, but it is there in India, and people are working towards deploying privacy. Welcome to my YouTube channel where you daily see new content on privacy. And as I said, let's talk about startups. What kind of issues they have been having and how can they get rid of these? So, what are the violations that regulators have observed worldwide and to a bit extent in India as well? No privacy policy. No privacy policy, no privacy notice. Lack of consent collection, it seems like a lot of people are still taking time to think about how to go about privacy. Incomplete consent records. Yes, you can understand if there is lack of collection, then how would records be good? Over collection of data. Startups especially think, let me get everything. Tomorrow I might devise a new marketing mechanism. So I might need this piece of information. And therefore they keep collecting as much as they can. And ignoring data subjects' requests, which is the most unfair thing, right? Because if people are trusting you because you have started business just afresh, then you should develop systems that can respond back and increase their confidence in you. Why are startups at risk? They are fast growing and they want to grow very fast. They want to pay very less attention to other things except growth. Therefore, they end up ignoring even the data life cycle. They store unnecessary personal data, as I mentioned in previous slide also. Let me have everything. I might devise a new mechanism. They use third-party tools. Yes, they do. But again, do they really check whether those third-party tools are good for privacy systems? They don't have a process of what? Consent management. It's a process. It needs investment, it needs time. And it is the most important process. They don't have a mechanism to respond to users, and they don't have a mechanism of grievance redressal, which is again a big issue. Grievance redressal. Where would your customers go or your data principals go if they are not satisfied with the way you are processing their information? What does DPDP Act expect? DPDP Act says you should have clear and simple language privacy notices. Clear and simple. You should collect valid consent even before you collect the data. That's very important. You should have a consent before collecting data. And actually, for startups who are mostly in app kind of situations, right? Their users are going to be there for a particular service only. It is not that they have 20 services, so you don't know. You don't know which service which user might like to go on for, though even that can be chosen and consent can be obtained when the user wants to add a service. But with most of the startups working with single service, their sign up forms should mention the purpose of each of the field and a tick mark of consent. So people can choose which one they want to use, which one they don't want to use. And they should follow purpose limitation. Purpose limitation will help them follow data minimization as well, right? Don't think that extra data helps. It does not. It can create problems instead. And even if you are overlapping your privacy jobs, being startups, do have a dedicated or overlap workload for a designated grievance officer, a point of contact where principals can come up and lodge their concerns. Develop systems that respond to the user rights. What are some of the common mistakes they make? They copy long global privacy notices, international, everyone looks at these. Let me copy paste and start using them. They may not be applicable and they may be too long for being applicable. Bundled consent. All personal information feed. I hereby agree that my data can be used to deliver me good services. All data items for good services. Purpose not clear. Consent actually invalid consent. That's not the way valid consent is taken. They don't track and monitor the data storage that they are using, and role based access may not be properly implemented, and they ignore the data sharing methods. They are uploading data to cloud SaaS providers. What are the contracts? Right? Many startups host applications on external cloud providers. what are the legal obligations, what are the data sharing or data processing agreements signed with them. Right? So a privacy checklist for startups, your privacy notices should be well crafted for your business and should be available on your website and inside your apps. There should be a granular consent mechanism on the sign-up form. There should be a possibility of having inventory of the data and a list of the vendors that you have. Right? So inventory has to be there. A list of vendors. But how does it help? It helps you ensure that you have good relationships and good data sharing agreements with your vendors. Grievance officer is a must because all regulators, including DPDP Act, they lay a lot of stress on user rights. And a single sentence covering most important pillars of data privacy: purpose driven minimum data collection, and of course with valid consent. So these are some of the very important things that a startup should follow. I hope you like the content of the video. Please press the bell and the like icon, subscribe to my channel, and share your feedback in the comment section. Thank you.